Welcome to Introduction to Talmudic Legal Logic. And today we're going to discuss two rules of interpretation which lead to broad and narrow readings of biblical passages. These rules are addressing something that is a perennial problem in constitutional and statutory interpretation that we have to deal with today. Do we interpret a particular constitutional or statutory clause in a broad way or in a narrow way? There are many, many cases in which we confront these questions, when we have to figure out whether a certain rule should be read in an expansive way or in a constricted one. Consider the possibilities. One of them is when a law, for example, provides a list. Is the statutory list closed or open? That is, does the law only apply to the list, or does it apply beyond the list, and we should just look at the statutory list as examples? And if we're given only one example in a statute, is that just something that proves the rule, or is the rule limited to the situation that's described in the example? Of course, we did not invent these interpretive problems, and as we're going to see, they come up in biblical exegesis for our Talmudic sages. And the Talmud tends to attribute two different interpretive approaches to this problem, one of them to Rabbi Akiva and the other to Rabbi Ishmael. Here are the two approaches. Rabbi Ishmael prefers reading biblical laws broadly, so applying every halacha, every question as applying to a very large number of cases. This method is called amplification and restriction, or in Hebrew, ribui v'mi'ut. Rabbi Akiva prefers reading biblical laws narrowly and applying them only to the specified situations that they deal with. His method is called generalization and specificity, or in Hebrew, klal ufrat. Let's talk first about amplification and restriction. Rabbi Ishmael's position is that when we look at a situation where we have a broad rule, that's going to be the default, that the rule really applies to the broad set of circumstances. And that means that if an individual example comes alongside a general rule, it means that the general rule applies, maybe sometimes with a small exception, or maybe the exception is just an example, but the rule applies broader than the exception. Rabbi Akiva's perspective is that when a particular detail happens in a law in proximity to a more general rule, it's there to explain the rule. Basically, it's there to illuminate what the rule applies to. Let's take some examples and see how these two different approaches, amplification and restraint, generalization and specificity, operate on particular biblical passages. Most Talmudic disputes that involve this issue, where Rabbi Akiva and Rabbi Ishmael take two different positions, involve one of the following scenarios. Either there's going to be a broad rule statement that's followed by a narrower statement, or there's going to be a narrow statement followed by a broad statement, or you're going to have a sandwich. Broad statement followed by narrow statement followed by broad statement. Let's discuss each of these situations in turn and take a look at some examples. So the first situation is broad statement that's followed by narrow statement, and the question is, do we look at this the way that Rabbi Ishmael would as ribui umiut, or do we look at this the way Rabbi Akiva would as klal ufrat? Here's an example. Exodus 21:25 lists the eye for an eye punishment principle that you probably remember from biblical classes. And among the things that are listed where a person is supposed to get their just desert, this particular verse, verse 25, says, Kviya tachat kviya, petza tachat petza, chabura tachat chabura. Burn for burn, wound for wound, bruise for bruise. In Talmudic sources, the biblical principle is not interpreted literally. So basically what they're saying is every time you hit somebody, you are not going to be hit in the same way. So if you gouge somebody's eye out, they're not going to take your own eye out, but rather the idea is that you pay monetary damages at the level of the harm that you've caused. And this is the basis for damage, for tort payments, monetary compensation for the injury. But this raises a question. Because this verse says burn for burn, wound for wound, bruise for bruise, does this mean that you're supposed to pay for any burn that you've caused, for any wound that you've caused, or for any bruise that you've caused? Or is the latter part of the verse an interpretation of the former, which is to say, you only pay for burns that resulted in bruises? So if you look at it the Ravi Akiva way, you're going to see that there's a narrow interpretation. The specific mention of a wound or a bruise is there to explain that the liability arises only for burns that cause wounds or bruises. Whereas if you take Rabbi Ishmael's broad interpretation approach, you're going to find that any burn, including those who did not cause a wound or a bruise, have to incur damages. So there you have it. For Rabbi Akiva, if it's klal ufrat, the prat wins. If it's Rabbi Ishmael's way and we have ribui umiut, the ribui wins. Now let's take a look at the next example. So here's a scenario where you have a narrow statement followed by a broad statement. Here's an example for a rule from Exodus 22, verse 9. This rule involves a situation where B has given A an ass, an ox, a sheep, or any other animal to guard, and while under A's care, the animal died or was injured or was taken, and there was no evidence to what happened. כי ייתן איש אל רעהו חמור או שור או שא וכל בהמה לשמור, ומת או נשבר או נשבע, אין רואה. Just so that you're not stressed out about what the solution is, the biblical solution is that if the person swears, I had nothing to do with it, if A swears that he had nothing to do with it, he doesn't have to pay B. And there's no evidence to say otherwise. But the Talmud is interested in all kinds of nuances and minutiae relating to this rule, including the question, does this rule apply to any animal or just to an ass, an ox, a sheep? Basically, what wins, the details or the minimization at the beginning, or the more general statement that follows the list of specific animals. It turns out that in a situation where a narrow statement is followed by a broad statement, both Rabbi Ishmael and Rabbi Akiva agree, and the statute is to be read broadly according to both approaches. What happens then in the sandwich situation where we have a broad statement followed by a narrow statement followed by a broad statement? Are we talking about ribui, miut, veribui? Or are we talking about klal, ufrat, uklal? Well, the theoretical formulation of the rule follows the exact rule that we've already seen when we talked about broad statements followed by narrow statements, which is to say, Rabbi Akiva would say narrow interpretation, klal ufrat uklal. The prat, the detail, is there to minimize the rule, to focus the rule. And Rabbi Ishmael would say ribui v'miut v'ribui, miut, which is to say we're going to ribui, which is to say we're basically coming back to the general statement and the rule is the general rule. But sometimes these sandwich or supposedly sandwich verses are not what they seem. Let's take an example. So here's Deuteronomy 11, verse 9, which involves kosher rules, and this time we're talking about what kind of fish or what kind of animals in the sea people are allowed to eat, and here is what the verse says. Of anything in water, all that has fins and scales in the water, the seas and the streams. את זה תאכלו, מכל אשר במים, כל אשר לא סנפיר וקשקשת, במים, בימים ובנחלים, אותם תאכלו. So you'll notice that there's actually a few pieces to this rule, right? It says in water, right? Asher b'mayim, that has fins and scales, kol asher lo snapir v'kaskesset, b'mayim, in the water, bayamim u'vanechalim. So we all agree that because snapir and kaskesset are what is limited here, that's what we're supposed to eat. Rabbi Ishmael and Rabbi Akiva are going to agree on that. And this, my friends, is the reason why in places that keep kosher, you will find all kinds of weird kosher shrimp dishes, because people can't actually eat animals that are not finned and scaled if they follow kosher rules. But the question is, should you eat anything that's in any water, or do you have to eat only what's in the seas and the streams? Rabbi Ishmael would say this is a trick question. The interpretation that has to follow here is a broad interpretation because the order is not the sandwich order that's drawn above. We have two general statements, right? In the water, followed by a narrow statement in the seas and streams. And in this situation, the interpretation has to be broad because the broad rule is followed by a narrow detail. So this raises a question, is there something mystical about a particular verse that can lead you just by looking at the verse to say, we should look at this as an expansion and contraction or as a rule and an exception? Is there something about the language that's going to be conducive to that? In modern laws, usually you're going to have some indications as to what kind of interpretive principle to apply, because the law itself would say things like, or other things, or it would say e.g., or it would say for example, and then you'd know that it's a broad interpretation. And if there's just a list with no broad interpretation, you could assume the list is closed. But in biblical verses, oftentimes this is not the case. It's very difficult to just look at a verse and just say the rule from Ribui v'Mi'ut should apply or the rule from Klal Ufrat should apply. So is this really, this dispute between Rabbi Akiva and Rabbi Ishmael, is it really about the test or is it about the outcome? Well, consider the following. In US constitutional law, we have three levels of scrutiny, which guide the balancing between governmental interests and individual rights. We have the strict scrutiny test, we have the intermediate scrutiny test, and we have rational basis. Almost always, when you read a constitutional law case, you will find that when the justices say that this situation merits a strict scrutiny test, that means the individual is going to prevail. And almost always, if the justices say this case, has a rational basis test, it's almost always going to lead to the government prevailing. And you might think the judges might be already signaling what the target is and then deciding what the test is going to be based on what they think should be the prevailing view here, the individual's view or the government view. Here, too, in this dispute between Rabbi Ishmael and Rabbi Akiva, it's quite possible that the Ishmael school, which is guided by broad interpretation, is merely using a formulation that gets them there, whereas the Rabbi Akiva perspective, which is guided by narrow interpretation, adopted a legal framing that gets them there, meaning that the rabbis are basically signaling what's the end outcome that they want to reach. They want to have a broad rule or they want to have a narrow rule, and they just later in sort of kind of like to justify or legitimize this position, they're going to throw one of the tests at it, ribui umiut or prat uchlal.